From supplementary list, item number 1.
Who is for the petitioner?
My lord.
You are for the petitioner.
My lords, this is also a legal aid matter. There's a 800 days in my lord. Obliged, lordship.
Number 2.
My lord.
Yes, the remaining
in terms
work to
of
be
this
completed, yes.
Order dated 4/11/2025. I think joint inspection has been carried out. We are waiting for a report, my lord. And
Who is the amicus?
My lord, I am appearing as an amicus, my lord. I have
You are
gone
the
for-
amicus?
Yes, my lord. I've gone for inspection on Sunday, my lord. On 23rd, I've inspected the route thoroughly, my lord, from the beginning till end, and the condition of the route seems to be very bad, my lord. In some
Very
part,
bad.
of course, some part, of course, my lord, the repairs have been made, but there are some parts the condition is very bad, my lord. I'm yet to, my lord, print the photographs. I'm praying, my lord, may have this matter on
How much
Monday.
is the stretch? How much is the stretch?
102 kilometers, my lord.
102 kilometers.
102 kilometers, and certain spots which my friend has forwarded the photos, my lord. Although it has not been printed, the photos have been forwarded. I have seen, my lord, it needs some attention. Some potholes has been there, and some small repair works are required, my
in
lord.
fact, my lord,
The major strengthening of the road has already been done, but other things also needs to be attended. Some small repair works, my lord.
The road is to be laid by you, maintained by you.
Yes, my lord. The national highway.
NHAI.
NHAI, my lord.
and my lord, there are few stretches which are still, my lord, in the form kacha.
My lord,
kacha
it will
road,
be
my
an
lord.
ongoing,
There is no-
ongoing process, my lord, to continually.
No, out of this 102 kilometers, how much you have been able to repair?
My lord, more than 99%, my lord. Only some spots, some potholes have been there. Some.
Let them have it home.
This is, my lord,
But he has home there. Yes, sir, you have.
photographs. I've already forwarded to the council, my lord. And the report which has been filed on the last occasions, it seems it's a misleading statement, my lord.
No, my lord, the major strengthening
It
of
has
the road
stated-
has been taken up, my lord. And besides that, my lord, certain portions, certain breakdowns were there on the damages on the roads were there, my lord. So what I'm praying, my lord,
I can file it on Monday, my lord. I prepared the report. I just need to take the photographs, my lord. The printed
Monday
photographs,
and the next week we'll go. We'll personally go and see.
my lord.
Yes, my lord.
Inform NHI that we'll personally go and inspect.
My lord, on the last occasion, my friend had gone with the NHI personnels also, my lord, and he has
Two engineers
prepared
were there, my
a
lord.
detailed report, my lord. My lord, that report, when it comes, my lord, it will help us to complete whatever portions needs to
Why
be.
you wait for a report? You have engineers. You know which
They are
stretch
doing
is-
it, my lord.
Which stretch is bad, which stretch is good. What kind of layering is required so that it can have longevity.
So what I am praying is that, my lord, if my lord grants us some more time, let it be after the vacation, my lord. In the meantime, I'm sure, my lord, there will be nothing left to be done, my lord. In the meantime, the photographs has already
This
been
matter is
forwarded.
pending for long. How long it will wait? Tell us. This matter is pending
my
since
lord, now that-
2023.
My lord,
22
now the overall strengthening of the road has already been done, my lord.
Do you require 3 years or 4 years just to strengthen for 102 kilometers? For 102 kilometers, you require 4 years.
Earlier, my lord, temporary repair works were carried
Why
out.
it was temporary repair? Why not permanent solutions being made?
My lord,
You ask your person, we'll go. We'll find out what is happening on the ground.
That will be better, my lord.
my
I would
lord,
also
that
pray,
will
my
not be
lord.
required, my lord. What I am praying is that, my lord,
No, it
will,
is required now. 4 years temporary patchwork is going on.
no, my lord, now the overall strengthening of the road has already, even the learned amicus will agree to us that major strengthening work has been carried out, my
My
lord.
lord sees the photographs.
My lord-
It's very disheartening, my lord.
If my lord allows, my lord, let the report be placed on record what my friend is contemplating, my lord, and thereafter, my lord, will kindly give us only 30 days time, my lord, and we would like to address all the issues.
That has been prayed since inception, my lord. My lord, I'll point out
We'll
the
go in
orders.
2 weeks' time. Whatever you'll do, do it. Absolutely. 2 weeks, we'll go in 2 weeks' time. So we'll just find out what is happening there. Have you paid the remuneration?
My lord, it is being processed in the course of the day will be.
What do you mean by 4th November, the order is passed, is under process?
My lord, there was some problem in the office, my lord.
The problem, the salaries of the persons are being paid or not paid?
My lord, I
They have
had
received the salaries.
personally
They
requested
have
the
received
office.
the salaries or not?
True, my lord.
Then we'll-
Myself, I have personally instructed the department, my lord, that during the course of the day it will be done.
If it is not done in course of
My
the day,
lord,
then we'll.
I bow down, my lord. I respectfully bow down, my lord.
We have heard the land council for the part. Yes.
My lord, we have come against the order passed by the Central Administrative Tribunal, my lord.
Acha.
But here what happened, my lord, the disciplinary proceedings were initiated. Of course, there was some delay, my lord, in initiating the proceedings, my lord, and in concluding the proceedings. Penalty was imposed, my lord. Now, the learned tribunal has quashed the proceedings, my lord, on the ground of delay. That too after conclusion of the penalty, my lord. Conclusion of
That
the
is after?
conclusion of the proceedings, my lord.
Listening, no?
My lord, kindly see page 58, my lord.
Enquiry officer acquitted him. Enquiry officer,
My lord.
so the disciplinary authority did not agree with the enquiry officer.
My lord, there are two charges, my lord.
So in charge number 2,
Yes, my lord.
the disciplinary authority disagreed with the finding of the enquiry officer.
Yes, my lord. And that is what's caused some delay in conclusion of the proceedings, my lord. The learned tribunal is caused only on the ground that there is a abnormal delay in concluding the
Just a minute.
inquiry proceedings, my lord.
He was on deputation.
He was on deputation to FCI, my lord.
Now, he left FCI in 2005.
In March 2006, my lord.
In March, no, applicant further stated that he left FCI in 2005. This is in 2005 or 2006?
My note says March 2006. I'll just look at my note. At page 400, the impugn order will also sees, my lord. At page 410, the last three lines, my lord.
Yes, March 2006, correct.
March 2006. my lord.
Yes. So he came back in March 2006.
Yes, my lord.
On the last day of service, 31st May 2011,
1 day prior to that,
while he was at the end of his farewell meeting, he was served with a charge sheet.
he
So after
superannuated.
6 years, you served him with the charge sheet.
Yes, my lord.
But the first issue is this: could you have continued with the disciplinary procedure unless your rule allows that? Could you have, under the service rules, you show us whether you could have continued with the disciplinary proceeding after the cessation of relationship? Because you cannot impose termination of service after the cessation of relationship. If your rule provides for that, yes, for the purpose of maybe recovering, maybe, I don't know, if the rule permits,
Yes, sir.
then for that limited purpose you could. For that purpose, there are some rules which permits. So
But the penalty imposed is a minor penalty, my lord.
No, that's not the point.
My lord.
Whether you can at all continue with the disciplinary proceeding or not after he ceased to be an employee.
But since the memorandum of charge was issued 1 day prior to his retirement, my lord. He retired on 31st May.
But could you continue with this after his retirement? It was done 1 day prior to that.
Yes, my lord.
But if it is not concluded before his retirement, what would happen? Can you continue with this?
But I do not have the office member number. But as far as I can submit, my lord, if the proceedings are initiated before retirement, my lord, that can continue. It cannot be initiated after the retirement, my lord.
No, that's true. That's true. So first charge number 1 was proved.
Yes, my lord. And charge
And
number
charge
2
number 2 was partly
partly
proved.
proved. Then
Now-
we had to send it to UPSC, my lord. And UPSC's advice was that both the charges are proved, my lord. Then the matter was referred to Committee of Secretaries in the Government of India.
This was in respect of a tender for the year
2004.
2004. Where's the charge sheet?
Start from page 73, my lord. Articles at page 75.
No, so how you explain that after 6 years you framed a charge sheet? What is his explanation? Why after 6 years? It has gone through audit. It has gone through audit, and he has categorically said there was an audit objection. That is a clear case. So from 2005 till 2011, all these things was processed, and there was no financial loss caused to FCI.
But our only case, my lord, the learned tribunal could have interjected if the proceedings were still pending, my lord, and on the ground of delay. Now, this is a case where proceedings are already concluded, my lord, penalty imposed. And after that, my lord, the tribunal's power to quash only on the ground of delay. Once it's completed, my lord, the scenario would have been different if it's not yet concluded, my lord. Proceedings are still pending. But here's the case, everything is crystallized, final outcome has come out, a penalty order has been imposed. And he approaches the tribunal after a penalty order.
Where is the order of penalty?
Penalty order is page 58, my lord. Starts from page 54, my lord. The 17th November 2017.
See, UPSC has said that rejection, what he decided, was on a valid ground. Correct? If you come to paragraph 9.3, rather 9.2. Let us read from 9.1. Let us read from 9.1. Whereas there are two limbs to the charge. The first part is avoiding of contract, who had similar financial credentials, and Sri tender was rejected earlier. Ramesh Brahma's tender was earlier rejected by the charge officer. The second limb is that different stands on two occasions for the same contract on similar issues was to favor private party at the cost of FCI, causing a financial loss. The first limb has been proved by the IO as well as accepted. Respect of the second limb has differed with the IO. As according to Commission, no nexus between the decision to scrap the earlier tender and to award the subsequent tender in favor of has been seen. CO in charge, through a detailed note, had analyzed the financial credentials and had given reasons for non-acceptance of the tender of Ramnath Brahma. Correct?
Well,
Despite the recommendation of the General Contract section, the EPS has held that the justice of rejection was based on valid grounds. And whereas records might have indicated that the credentials of Caesar was weaker compared to, as he was neither an existing or a contractor, have any experience, his experience was in the construction of dam road. And this was for FCI, this contract was for
for transportation.
for
Transportation of food grains.
Transportation. Now you said that CEO ensured the decision-making power remained with him. So as ZM in charge, ZM general manager, zonal manager in charge, by not taking up the tender process for the ad hoc arrangement and delegating it to the SRM. SRM is your senior regional manager.
Regional.
What? Huh?
Senior regional manager.
The CEO ensured. Now, any charge sheet against or any proceeding against SRM?
My lord, I was holding both the charges, my lord.
SRM and
And
Yes. Yes, my lord. CEO as the SRM chose to recommend the case of Sagar Basumatari.
Yes, what do you have to say?
My lord, there are two aspects of the matter, my lord. First is the delay. We argued before the tribunal regarding enormous
You
delay,
have not challenged the initiation of the disciplinary proceeding.
that when the
You
charge
have
sheet was
only
issued.
yes, so you have only challenged the final order of the disciplinary authority.
My lord.
So whether there was an initial delay or not, that point is no more available to you.
My lord.
So it's only restricted to that whether the disciplinary authority was justified in imposing the penalty or not.
No, my lord.
Every delay does not result in.
Yes, my lord. That is the law, my lord. Yes.
So the tribunal has proceeded merely on the basis that there was a delay in initiation. The judgments relied upon may not have.
Tribunal has gone to both things, my lord. Worship, kindly see, this incident took place from
No, tribunal has relied upon two decisions, which says that delay in initiation is likely to prejudice you. Now, there is no case of prejudice as such being made out that by reason of the delay, you are unable to produce any witness
my lord.
or you are unable to refer to any documents. And hence, the tribunal, the inquiry officer, charge 1 was proved, charge 2 was partly proved. You made a representation before the disciplinary authority. Disciplinary authority did not accept the UPSC recommendation and said, because the committee of secretariat said that it should be 30 or more than 20% in the given facts, and exercise the discretion of 30%.
UPSC says that both the charges are partially proved, my lord.
Yes, so both charges are partially proved,
Partially proved.
and the disciplinary authority says that both charges are proved.
My lord.
So it's between partial and full proof.
My lord.
So this is a process which has gone into. You had participated in the process. You have not raised any objection that the initiation of the charge sheet was wrong. You did not challenge it. You participated. You led your evidence. They have also led their evidence. After the evidence is concluded and the judgment and the decision is arrived at, the disciplinary authority, on the basis of certain documents, has arrived at a finding. Now, the tribunal has proceeded merely on the basis that the initiation was.
Initiation as well as completion, my lord.
Yes.
Completion also they have taken 7 years. Well, I'll place a judgment. Vigilante judgment, my lord.
Completion may be after 7 years.
My lord.
But if the charge is proved,
My lord.
then
No, my lord. Completion time under the circular was given is only 6 months, my lord. I am a retired government servant, my lord. As of today, I am 74 years age, my lord. I am
that's
studying.
true. But 7 years maybe. So for the initial 2 years only, rest at 30% is for the first 2 years, not for the entire
No,
period.
that is the penalty being imposed for recovery, whatever. That is the penalty has been.
No penalty was imposed. It says 30% of the pension, monthly pension for 2
That may
years.
be calculating the loss that has been caused to FCI, maybe, my lord.
Because of the difference in price of 420 increased by 70 per metric tons. That was the reason. But I think all gratuity, provident fund, everything has been released by this time.
Everything has been given. Now only the pension is being deducted
So 30% of the monthly pension.
for 2 years.
So for 2 years. So this is the monetary thing. Now they have given a reason for that. They have said so. Where's the page you have just shown it to me? Just now?
Yes, 58.
You know, it is 54, my lord.
Yes, 58. Yes, 10.4. The chain of events in rejecting the tender of Southern Church, noting on file that scrapping of the contract may result in higher rates in the next NIT, and finally approving the tender at rupees 420, which was after 4 rounds of negotiation approved by the CEO himself, still rupees 70.10 metric ton more than the market rate, indicate that the intent of the CEO was malafide and done to favor the private party. And this, so far as the one in whose favor you have given the contract, that is Shagor Boshumatai,
Yes, my lord.
he has experience not in transportation, he has experience in construction of dam. So on the basis of his financial capability, or other financials, you said that it's financial. Financial superiority of this. So financial superiority cannot be a reason. Anyone having a transportation and constructing a dam, financial superiority is not a reason. Then what is the wrong with the
So
order?
for the cancellation of tender is concerned, my lord, the earlier one, that cancellation tender of Ramnath Brahmo, my lord, I'll take your lordship
No,
to
no,
that.
that
I'm just
was
submitting.
that was cancelled.
Now, that's why that was cancelled, my lord. Lordship, kindly see. There were 10 forms, tender forms were purchased, but only there was single tender. There is a guideline that if there is a single tender, normally it should be cancelled because there is no competition. Here, it was so suspicious, my lord. 10 forms were taken, one tender came up. This is one reason. Second, my lord, his tenders were much below than the existing rate and everything, my lord. That charged officer, the respondent, my lord, has given 2-page note giving all justification that why this tender cannot be given to him. Well, as an officer, my lord, I have to discharge my responsibilities with a reason order, my
Single tender, very well, single tender, you may say that single tender I am not accepting.
lord.
But when you accept the second tender,
My lord,
second tender is in favor of Boshumati.
Bashumal.
Now the reason for accepting is because of his superior financial condition, financial superiority.
Page 71 may be kindly seen, my lord. Why it was cancelled, that on the basis of note, my lord. It was not my view, my lord. It was the view of the department also, my lord. My lord, as an officer, if I, even after all these things, I give it to the single tender, my lord. There is a guideline that this is the note, my lord. I have considered all pros and cons, my lord.
Now DM Kokrachar has mentioned that party is financially not sound and solvent at present.
Yes, bank certificate is there, my lord. He was financially very bad, my lord. I have enclosed it.
No.
From
While perusing the observation documents available in the file, the following status: DM mentioned that party. Which party? Which party?
That parties that time Ramnath Brahmo is Sagar Basumatari was not there, my lord. He came in the subsequent
Ramnath Brahmo.
Ramnath Brahmo, my lord.
So Ramnath Brahmo is financially not sound. So these observations
There
corroborate.
is a bank certificate, my lord.
Art of Finance has also found the tenders
Page 70.
not found tender from the observation. Party could not produce registration book such and such. It's quoted at the existing such and such.
Party has quoted 23% below the market rate, and it is unlikely.
Correct. It's not.
The finance and account and all other officers they say
So the ad hoc contract was initiated.
initiated because it was
Ad
at the
hoc contract was initiated because there was urgency.
urgency, time gap.
Now, what is that ad hoc contract was initiated? It's 20,000.
It was immediately. That is not in controversy, my lord. A spot tender was given, my lord. And thereafter, the regular tender was given to Sagar Basumatari.
No, regular tender was given to
Sagar Basumatari.
Sagar Basamatari. But Sagar Basamatari has no experience in transportation. He has an experience in construction of dam under the PWD.
No, my lord, experience is not in FCI. Anybody can apply, my lord. Anybody can, individual
Everybody
and
can
all, my lord.
apply, but
On the ground of experience, it was not turned down by Lord Ramnath Brahmo. Ramnath Brahmo, Lordship, kindly see,
now on financial ground.
on financial ground, his banking transaction was bad. There was a single tender, and his quote, his rate quoted, my Lordship, kindly see, that page 71. That was the main ground, my lord. In the middle, my lord, after, in the third paragraph, my lord.
Now, huh? Below the existing rate, 23% below the current market rate, 18% less than similar distance rate. Quoted contract manual about the workability which provides for verification. In his note has observed that the clauses are not applicable in this case as the quoted rates are for entire distance. How is this logic relevant?
Well, this finance and account also opined that this is not applicable. I mean, they are,
But it seems that participation.
I've taken into consideration everything and then passed this order, my lord. And it was a single tender, my lord. And there's a guideline which I have enclosed, my lord. Single tenders normally should not be allowed, my lord. And Lordship kindly see 10 persons have taken form and only one has filed, my lord.
Now, here's also this Bromo worked for 9 months.
9 months, my lord. It is not that somewhere it is mentioned 2 years, but the officer, the petitioner, respondent has said that no, he has only worked for 9 months, my lord. And his banking, Lordship kindly see page 70 for a moment, my lord. The bank says that the transaction of the account presently found not to be satisfying. His financial condition was also bad. His bid was also too low, and there is every possibility that halfway he will give up and create a chaos for us. So I, being the authority, my lord, I have given a reasoned order. There may be, my lord, but I have followed the procedure, my lord.
No, but so far as the credentials to be there for such contract, is he a past experience in transport if it is there, and if you have ignored it, what is the experience required? Past experience is required.
No, past experience is not here. Anybody fresher can.
No. Where is that?
Profit and loss comes later. Needs to be seen that whether the power was diligently exercised or not, my lord. Supreme Court has laid down, my lord, when it is misconduct. Now everything is connected with loss and profit, my lord. Then the officer cannot function, my lord.
Lack of financial soundness. Bromo was one of the existing contractors.
Yes. But page 63 is the NIT, my lord, the tender notice.
Page
63. Third sentence, my lord. Invite sealed tenders from the experienced and financially strong parties.
And Lordship kindly see the bank certificate he has given, my lord. He has given the bank certificate. We obtained, my lord. We obtained from the bank and say that his transactions condition is not good.
Where is the finding of the disciplinary authority?
That will be page 54, my lord.
Is the disciplinary authority?
While passing the impugn order.
Now then, why it has gone to UPSC? Why it has gone to UPSC under what provision? Under what provision it has gone to UPSC?
But page 232 may be seen once, my lord. In what manner the proceeding was drawn, my lord?
UPSC has, why it was sent to UPSC?
My lord.
Now, why it was sent to UPSC? Is there any...
My lord, this may be possibly, the rule says that, may I read it, my lord? The Assam, my lord, that All India Services Disciplinary Appeal Rules, my lord. In case of major penalty, my lord, possibly this is the reason, my lord. May I read it, my lord? 9.3 says that if the disciplinary authority having regard to the finding on all or any of the articles of charges is of the opinion that any of the penalties specified in clause so and so of rule so should be imposed on the member of service, it shall, notwithstanding anything contained in rule 10, make an order imposing such penalty. Provides your lordship kindly see, provided that in every case the record of the inquiry shall be forwarded by the disciplinary authority to the commission for its advice, and such advice shall be taken into consideration before making any order imposing any penalty on the member of service. Maybe, my lord, commission refers to Public Service Commission, that is mentioned, my lord. It's 9.3 proviso.
This is your, this All India Service Disciplinary Appeal Rules.
My lord, 1969.
I need the book.
Next.
We have annexed is incomplete, my lord, page 424. It's up to rule 9 only, next one.
So were you heard on the basis of the recommendation?
No, my lord. In fact, there was some note given by the disciplinary authority to the UPSC, my lord. I asked for that note, that was not given. I made RTI application. They said, no, it's a private document. I cannot give it to you. That is not given, my lord.
No, note made by
By the disciplinary authority
to
to the UPSC, my lord.
no UPSC has given its findings.
My lord. That both
UPSC
the
has given
charges
its
are
findings.
partial.
No. After UPSC recommendation,
My lord.
this copy of the recommendation was given to you,
Yes, yes.
and you made a representation
Yes,
against that
yes.
recommendation.
Yes. That is page 169.
No, so after that, you made a representation to the
Before the disciplinary authority, my lord. 169. 169, my lord.
Yes, but the premise of the order of the Central Administrative Tribunal is wrong. Central Administrative Tribunal has not decided whether the quantum of punishment was correct or not. Central Administrative Tribunal has proceeded on the basis that the entire proceeding is quashed. That is a wrong decision.
No, Central Administrative Tribunal only has considered the delay aspect of the matter, my lord. On the basis of
That is immaterial.
no, my lord. If
immaterial.
delay, if your lordship kindly see, there are two judgments which has been relied.
No. The judgment has to be read contextually. Here, entire evidence has gone. Entire evidence has gone, and then there is a finding.
My lord,
You have not challenged the initiation.
my lord, I respectfully submit, my lord. I'll place a judgment, my lord. Vigilance judgment. They are, my lord. There was 7 years delay in initiation and 6 years in completion. It was completed. Then it was challenged. Supreme Court said that it cannot do this. Well, one judgment, I should kindly see, my lord. My lord, only because when a show cause notice is given, my lord, it is not an advance document. There is something against me. There is an inquiry. You say something, but that does not obliterate the fact that
you should have challenged the very initiation.
I could have, my lord. I could have.
After you having participated in the said proceeding, suppose you were acquitted today. You would not have said.
I will not say, my lord. Yes.
So you participated in this, at every stage you made your representation, and thereafter the finding is arrived at. At this stage, you cannot say that the initiation was bad. I would have followed that it was wholly without jurisdiction. Suppose an authority has imposed a punishment on you who is not authorized by the law. Say, whatever time you challenge is immaterial, because if this is sought to be enforced against you, this cannot be enforced because that authority do not have the jurisdiction. But this is not the fact here. After having you participated, at every stage you participated, every stage you made a representation, and then the disciplinary authority has come to a finding. So at this stage, you cannot say the tribunal may have gone into whether the punishment imposed was proper or not.
That is not.
So that would have been the situation. But this order, just because there is a delay, so it has to be initiated, is a wrong order. We may remand the matter to the tribunal for fresh consideration on this, leaving it open, so that suppose if we decide anything, that will be you will have no recourse to this. So you decide the tribunal to decide the matter afresh.
My lord, may bear with me, my lord. 232 may be seen, my lord. Page 232, my lord. Lordship kindly see.
Yes, what is that? Please tell us.
That is the written statement filed by them before the tribunal.
That is not the point. That is not the point, please. The tribunal has relied upon two decisions which do not have any bearing on the facts. There it says that delay, there may be a presumption by reason of the delay you are unable to produce the witness.
My lord, their judgment says, my lord, when it is delayed by...
Suppose on the verge of your retirement, suppose it found that you have defalcated crores of money.
My lord.
And if the proceeding is initiated, you participated
My lord.
at every stage. And after that, at the end of the day, it found that you have defalcated, say, 1 crore of rupees.
My lord.
So will it be a ground that every delay does not automatically
Every delay
result?
not. Every delay
It has to be decided on the facts of the case.
My lord, there are two aspects of the matter, my lord. Delay, so far, my lord, here also filing the writ petition, they have done delay of 1 year, my lord. Here, this petition, my lord.
That's not
But
there. We may remand the matter to the tribunal for a fresh consideration on merits.
On merit.
That's all on merits.
In
Lordship
fact,
kindly
in-
see 232, my lord, for a moment, my lord. Lordship kindly see how I have been dealt with, my lord. Lordship kindly see, my lord.
That is on the merits. See, tribunal
No,
has
not merit of
tribunal
the-
has not gone into the merits of the matter. Tribunal has proceeded on the basis that the initial delay was wrong. That's the judgment of the tribunal.
My lord.
It has not gone to the merits.
My lordship kindly see for a moment, my lord, for my satisfaction, my lord.
Yes.
How the DP was drawn, lordship kindly see. 7 years they are sleeping over the matter and what they have done, lordship kindly see. 232. They have given the details here. My lord, on 26th of, my lord, I am retiring on 31st. 26th of May, 4 days before, my lord, FCI has gone to our authority, discipline authority, saying that issue a charge sheet. FCI, not the discipline authority. Now, lordship kindly see, it was put up before the discipline.
But FCI is your employer.
The deputation part only. I am IS officer in the DOPT, my lord. I repatriated in 2006, my lord. And how do I remember all these things there, my lord? Is it possible, my lord, when I was deputed in Northeast in 2004-5, my lord, 2002-3, my lord, then something happened and I'm retiring on 11, my lord. I remember everything, my evidence and everything. That is the reason, my lord, Supreme Court has said, my lord, prejudice has not to be pleaded. It is there.
You have to urge at that point of time that the initiation was mala fide. But if you have delivered your defense, no prejudice was caused to you because you know the entire
No,
facts. This entire file was produced. Your note sheet was produced. Everything was produced.
Now, this fact came in the proceedings of the case when they filed a written statement, my lord.
Yes, so it's not that you have not been allowed to inspect any documents,
My lord.
or you have not
But
been
these
allowed
facts
to.
cannot be obliterated by my not challenging, my lord. Lordship, in a judicial review, my lord.
Every delay in initiation does not by itself make this.
Exactly, my lord. That is the law, my lord. In every case, I cannot say the delay is gone. It cannot be, my lord. Now, Lordship, kindly see, UPSC says the matter happened between 2003 to 2005. So 8 years of delay. I was repatriated to my parent department in 2006. Thereafter 5 years, I have retired from service. How am I mean, the prejudice, Supreme Court has said, prejudice has not to be pleaded. It is there in the facts of the case, my lord. And my lord, my humble submission is that the delay in initiation of the proceeding, if I have not challenged at the point when it does not my lord, amount to waiver, my lord, I can always challenge in culmination of the proceeding. This is my submission, my lord. On the basis of the decision, I will be relying on, my lord. There are basically 2 decisions, one Mahadevan and Bijlani. That has made everything clear, my lord. And Lordship, kindly see, they have tried to explain the delay
See, the paragraph 10 is the judgment. Paragraph 10 and 11.
of the tribunal.
Yes, paragraph 10 and 11 is only. They say that delay, inordinate delay in
Yes, yes.
initiating and they have referred to the
2 guidelines, my lord,
2 guidelines
and 2 judgments.
and they are guidelines, not statute.
Yes, my lord, that is the guideline.
They are merely guidelines.
My lord, 6 months is the time given under the guideline. That 6 months time, within that you should try to complete it. They have taken 7 years, my lord. I have given service the entire life, totally unblemished career, my lord. On the last day, they have slashed it. 7 years, my lord, I am entitled to, my lord, Article 21 is violated. I'm entitled to have a peaceful life. Another fact which is not connected, on that day, another charge sheet was given. Now that charge sheet, they have given the impugn order of punishment against this, my lord, in 2023, my lord. I am 74 years person, my lord, lordship, this kind of thing is happening with me. How 11 and 12 years time is given to complete a departmental proceeding, my lord? And what manner, my lord? Disciplinary procedure, my disciplinary procedure did not apply its mind, my lord. It came from FCI 4 days before, my lord. And it was put before me, it was approved, and the showcause was slashed upon me on the last date, my lord. That's why, my lord, at the cost of repetition, my lord, I'm repeating, my lord, two judgments I'd like to read, my lord. You should kindly see on the delay part. And also while filing the repetition, my lord, there is not a single line why 1 year delay has been done in filing the repetition, my lord. But it is expected, my lord, 1 year delay is not, there is not one line, my lord. Always saying that government things take time. I'm in the retirement life, I'll not possibly, I don't know how long I'll survive, my lord. I'm for treatment, right now I'm for treatment in Bangalore. 74 years, man. Now the delay, my lord, I am contending, my lord, lordship may reject it, that's a different thing. Two judgment, I am relying, my lord, lordship kindly see. That vigilante judgment, lordship may kindly take for a moment, my lord.
Yes,
That fact situation is exactly fitting in my case, my lord. The vigilante judgment is, my lord, 2006, 5 SCC 88, page 88, my lord.
No, these judgments are referred to in the judgment.
No, vigilante judgment was, I relied upon, my lord. I don't know, my lord, why judgment is, that was not referred to, my lord.
Yes, yes.
My lord, I'm just reading the relevant paragraphs, my lord. Paragraph 16. So far, the second charge is concerned, it has not been shown as to what were the duties of the appellant in terms and so. First, may kindly come to the light. Last two. The tribunal, as also the High Court, failed to take into consideration that the disciplinary proceedings were initiated after 6 years and they continued for a period of 7 years, and thus initiation of the departmental proceeding, as also the continuance thereof after such a long time, evidently prejudice the delinquent officer. In banishing, my lord, is the starting point of delay, my lord. Then paragraph 19, my lord, it is really a matter of regret, great surprise. The disciplinary proceeding was initiated 5 years after the appellant had handed over the charge. At that time, he was admittedly not having possession of any documents. The inquiry officer furthermore took a period of 7 years to complete the inquiry.
See, in banishing, it was challenged before the departmental proceeding was actually initiated.
Yeah.
One is a conclusion. That is what I'm saying.
10 years.
These are the prejudice.
That's why prejudice has been recited here, my lord, saying that when I handed
In
over
all
charge
these
long
matters
back,
that you are citing, in all these matters, it was said that I am, because of the delay, I am unable to adduce evidence.
my lord,
So how can I prove? 6 years, 7 years is there. I don't have
I have
recollection.
understood that I have understood the point of view, but what I submit, my lord, my not challenging does not obliterate the fact that the disciplinary proceeding authorities were sleeping over the matter for 8 years. That does not obliterate, my lord. After 8 years before you knew, 2004 you knew all these things. Then 2000 on the last date, my lord, okay, you have done it. Do it within, I am a retired person, do it expeditiously. Another 7 years. Lordship may understand, my lord, what kind of atrocity goes on with the retired person, my lord. And other proceeding, my lord, Lordship kindly see. That is completed in 2023, my lord. When I will sleep peacefully, my lord? When? I am a retired person, my lord. They are entitled to have a peaceful life, my lord.
My lord, kindly seize the OA, my lord. I'll before the tribunal. 19 grounds have been taken, my lord. 18 are on merit. And only ground number 7, lords, kindly seize, my lord. At page 47. So, my lord, page 45, my lord. There's only one ground taken on delay, that only for initiation, my lord.
Very well. Any other decision you would like to say?
Well, that has been relied by the tribunal but not all the paragraphs have been.
Give us the decision.
Haan, my lord, I'm coming. PV Madham, that is the 2005 6 SCC 636. But I'm just reading 2-3 paragraphs, my lord. Paragraph 3, 4, 5, and 11, my lord.
Yes.
My lord.
In the circumstances allowing respondent to proceed further with departmental proceedings at this distance point would be very prejudicial.
My lord. So, my lord, it was challenged when the charge sheet was issued. Well, that's why I said that earlier judgment, Bijlani's judgment is on my point, my lord. Bijlani's case, what happened, my lord? 5 years time they took to initiate the proceeding, and 7 years time they took to complete the proceeding, my lord. And Supreme Court has said, my lord, that, my lord, how, my lord, prejudice is not to be, it is apparent on the face of the record, my lord. How after 8 years, my lord, I remember everything, my lord, I am as IS officer posted here and there, and how I go back to FCI and do everything, my lord. And why you were sleeping over the, it was so, my lord,
Take
my,
down.
may I please your lordship file the rejoinder on Monday and the compilation of judgment and written notes also prepared, my lord. You can file now, my lord.
It's you are appearing.
My lord, we just
What is
received
this
a copy
matter?
of the rejoinder yesterday, lordship. So our written submission is under process, my lord.
What is this matter?
Lordship, they are questioning the maintainability of the amendment made, the notification issued by the government, my lord, with regard to pre-primary teachers.
Challenge the virus of the act, my lord. To
We can
act.
hear it out, no problem.
Yes, my lord.
Start.
Well, we'll file our written notes and compile it.
Compilation. Bring that. That will print out. No, bring that.
Written notes. Okay. Yes.
Send that reports to my chamber.
My lord, my argument is on twofold, my lord, on two grounds, my lord. One is, my lord, violation of basic structure theory, my lord. And second is, my lord,
Basic structure theory, how the basic structure is
yes, my lord.
impaired.
Yes, my lord. Now, there's, by this Impugn Amendment Act, my lord, they encroach in the independence of judiciary, my lord. There is judgment which...
Provided it nullifies the judgment.
Yes, my lord. Now I'll come to that, my lord. I'll have an argument
The
on
issue is whether it is nullifies the judgment or not.
my lord. Yes, my lord. My lord, in S.R. Bhagwat judgment, my lord, mandamus...
Please don't go to the judgments. First, please tell us the facts.
Yes, my lord.
Then the judgment will come later.
My lord,
If there was a defect and that has been cured by the legislature,
my lord. Yes.
then that is
But I'll come to the
is
facts, my lord.
permissible.
I'll come to the facts, my lord.
Yes.
My lord, fact is, my lord, here, my lord, the on failure on the part of the
Give me the judgment. Give me the judgment.
petition.
This matter, the judgment. Trial court judgment.
What about the petition? And
Give me the trial court judgment. Separately.
Yes, my lord.
No, I have marked it.
The early judgments.
Give me the
Division bench judgment.
Then judgment.
the order which has been appealed against. Yes.
Division bench judgment, the early case.
My lord, I have annexed in my writ petition, my lord.
So where is the judgment passed in this matter?
My lord, I have annexed, my lord.
No, I just marked this.
My lord, page 42 in my writ petition, my lord. Annex of 5, the division bench judgment, my lord.
With the memo of appeal, what is that memo of appeal? What is that? You are challenging the judgment of.
No, my lord. We're challenging the Amendment Act of 2018, my lord. Section
You are challenging the amendment. Act.
amendment. My lord. Yes. After passing of the division bench judgment, my lord,
Oh, that
on-
is in division bench. Where is
on
valid?
13/10/2017, when the respondent are party to the proceedings, my lord, in learned single bench as well as before the learned division bench, my lord. After passing the judgment, the legislature resorting the route of amending the Parent Act, my lord, 1993.
It's a clarificatory.
Well, yes, my lord.
Someone would not qualify. He was given the benefit. He's being taken out.
My
So
lord,
that will mean that you have a vested right. Can't be.
my lord, my lord, kindly see the manner in which they are
Talking
participating
about the
in
manner.
the-
You see that why it was just a SSI judgment.
Yes, my lord.
That is the judgment you said has been nullified by the legislature. Correct?
That is, and this division bench judgment, my lord.
That's very well.
Yes,
so
ma'am.
what was the thing? What Justice Sen has said?
Yes, my
To
lord.
read the judgment is better.
Yes, my
That is
lord.
at page 52, I believe.
My lord, yes, my lord. May I read, my lord, the para 6, from para 6, my lord. The single bench judgment, my lord. In my writ petition, page 40, my lord. In my writ petition, page 40, my lord. Last portion, my lord. My lord, have. After careful analyzing the word used under section 3 clause 1 of the Meghalaya taking over the District Council Lower Primary School Act 1993, it is clearly understood that the
Yes. Yes, that is the thing.
yes, my lord. May I read, my lord?
Paragraph 5.
My lord, in single bench judgment, my lord.
Yes.
Paragraph 5, yes, ma'am. After hearing the submissions advanced by the learned counsel for the parties, and after going through the petition and act referred above, and on perusal of section 3 clause 1 of the Meghalaya taking over the District Council Lower Primary Schools Act 1993, it is clearly mentioned that on and from the appointed date, all the DCLP schools in the autonomous district shall stand taken over by and vested in the state government. Section 3, clause 1 of the Meghalaya taking over of the District Council Lower Primary School Act 1993 is reproduced herein below for ready reference, my lord. Section 3.1. On and from the appointed date, all DCLP school in the autonomous district shall stand taken over by and vest in the state government. Para 6, my lord. After careful analyzing the word used under section 3, clause 1 of the Act Meghalaya taking over the District Council Lower Primary Schools Act 1993, it is clearly understood that the Act is silent to make any kind of restriction between the pre-primary teachers and primary teachers, as the word used in the said section DCLP school. Yes, ma'am.
Yes.
Yes, madam. DCLP school means District Council Lower Primary Schools. Since the Act is silent to define anything separately about the pre-primary, in my view, pre-primary schools are also, also falls within the ambit of DCLP schools. Since there is no different segment between the pre-primary schools and
Now
primary
this
schools.
distinction has now been made.
Yes, my lord.
Now, if you are challenging the distinction, I think now it has come back to my mind.
Yes, my lord.
If you are challenging this distinction, then you file a separate writ. Filings cannot be challenged. This is not to nullify. You may say that there is no intelligible difference here.
My lord, I'll come.
That is the Tendulkar's case.
My lord, I'm relying on that. my lord. Yes,
See,
ma'am.
time is precious, so we should not. So
My
I'm
lord-
saying that this argument.
Yes, my lord.
This argument is this, that it was silent. Now the state government has made classifications.
Yes.
It's not to nullify this. His lordship has not considered that had there been a classification, then whether this classification was justifiable or not.
That is second argument.
No.
Yes, my lord.
That's the point.
Yes, my lord.
So he said, since it is silent, so Justice Sen read into it,
My lord.
that since no distinction is made, so it also is beneficial to any or to them.
Yes.
Now the legislation has made it, the basis of this
Yes, my lord.
has been now, they have made a classification.
Classification, yes, my lord.
This is not to nullify this judgment.
My lord,
They supply the basis for whatever they have done may have that time, but in absence of any clear-cut legislation, the argument was not accepted. Now they made a classification. If they made a classification, then if you say that this classification falls foul
yes, my lord.
of Article 14, then that can be a separate matter of litigation, not the matter of litigation on which the virus can be challenged, on the ground that it nullifies the judgment of the decision being.
My lord, kindly, my lord.
You understood it?
I understood, my lord.
So,
the basis
You
of the
understood it also on the last occasion.
My lord, yes, my lord. Yes, my lord, I understood, my lord. Still, I'm take my chance, my lord, on the issue, my lord. My lord, because, my lord, the judgment, my lord, the learned single judge and the division bench, my lord, the basis of the judgment is to extend and release the benefit to the pre-primary, my lord. Now, my lord, after failure in the division bench proceeding, my lord, the legislature all of a sudden, after almost 30 years, my lord, after almost 25 years, my lord, they invoke judicial, my lord, legislative power and amend section 2E, my lord, whereby they have excluded the
and they have given a
pre-primary.
reason.
My lord, no reason has been given, my lord.
The preamble is a reason. Why
Yes,
is
my
no
lord.
reason? Yes, yes. Find out that. It's
Yes,
there.
ma'am.
It's there. What is that page? Just
My lord, page 57 in my writ petition, my lord, page 56, annexure 8, the 9th October 2018, first amendment, my lord.
I think you have filed your affidavit, no? There you have explained it.
My lord, we have.
They have filed an affidavit
In
explaining
the
it.
affidavit, my
Just
lord.
give the affidavit. Just give the affidavit. We have marked it there. Just give the affidavit. Yes. They have given the justification.
In their affidavit, they simply stated that they have cured the defects, my lord.
No, they have given. Not merely that. This is by Swapnil Tembe.
Swapnil Thambe, my lord. Yes.
My lord.
Yes, ma'am. They have stated in page 5, my lord. The first affidavit.
To clarify the defect which was pointed out in the judgment, in which non-segregation of pre-primary teacher and primary school teachers.
Yes, my
There are
lord.
two different classes.
Yes, my lord.
For a qualification of a pre-primary teacher and a qualification of a primary teacher are different.
My lord.
They have to be in a two different scale of pay, grade of pay.
My lord, yes, my lord. My lord, why the legislature has used the term and expression DCLP while taking over in the year 1993, my lord. Because, my lord, in pre-primary school, in lower primary education, my lord, in the state of Meghalaya, prior to 1993, there was 3-4 sect of teachers combined DCLP, basic junior school teacher, lower primary teachers, and pre-primary teachers, my lord. These are combined, which is why the legislature used the term DCLP, which combine all three group, my lord, and take over with an intention to safeguard those schools, because on the failure on the part of the district council, while district council could not manage the affairs and functions of the school, the state government
Please tell me one thing.
Yes, my lord.
The qualification for the pre-primary school teacher and primary school teachers are same or not?
My lord, no, my lord. There's
That is answer.
my lord,
That is answer. You cannot put them.
my lord, pre-primary, when they were appointed, they were matriculated, my lord. Secondary school.
So if it is not in the one bracket,
Yes, my
Mr. Counsel,
yes, my lord.
then there cannot be any nullifying a judgment. This is the same thing happened with that excise salt matter of the Supreme Court. I think this is
Excise, sorry, my lord.
excise salt matter. This is definitely the same thing came up for consideration. Just the allegation was that you tried to nullify the judgment of the Supreme Court.
My lord, I'll just, my lord, if my lord permits, then I'll rely on judgment, my lord.
No, judgment will come later. Let us have the
Yes,
facts.
Yes, my lord.
If there are two groups, recruitment rules are different. Their curriculum is different. They are teaching, one is teaching the pre-primary, one is teaching the primary. They cannot be on the same bracket.
No, my lord, they are in the same schools, my lord. Division bench.
Maybe in the same school. A school may have a pre-primary section, primary section, secondary section, high secondary section.
Yes, my lord.
So for each, they may have a separate scale of pay.
My lord, the first they were appointed by the administrator. Then, as well as the primary teachers are also were appointed by the administrator, who was appointed by the governor.
Could be,
My lord, yes, my lord.
could be possible.
My lord, now the judgment, my lord, what is the basis of the judgment which passed this honorable division bench, my lord, to release the benefit at par with the lower primary teachers, my
It
lord.
cannot be at par.
My lord,
It cannot be at par. It was at par because the act was silent. That is why Justice Sen interpreted this.
yes, my lord.
You are not being able to show that you are discharging the same function. Can't be.
Well, discharging,
Qualification will be different.
my lord,
Merely because you may be high qualified, that would not inure to your benefit.
my lord, we are, my lord, in the same schools, we are teaching the same, my lord, pay scales, my lord. My lord, with regard to the salary, my lord, I am not aware right now, my lord, whether they are availing the same scale of pay, my lord.
That whether this cannot be said to be nullifying. They are clarifying, they are removing the defects.
By curing their defects, the judgment of the learned single bench at the division bench were nullified, my lord.
No. Had there been a decision is an authority for what it decides.
Yes, my lord.
Now, after this act, when it was made, there were right to education act came.
Yes, my lord.
Now, when Justice Sen decides a matter,
Yes, my lord.
that act was possibly prior to Right to Education Act.
Yes, my 1993 act, the parent act.
Yes.
Yes, my lord.
Now, by reason of the Right to Education Act of 2005,
Yes, my lord.
the entire complexion has changed.
Yes. So many changes after right to education, my lord.
So
Yes.
it cannot be said that.
My lord, but these teachers, my lord, the petitioners herein were appointed, my lord, prior to the Right to Education Act, my lord. In the 90s, they were appointed. My lord, on the same, there with the lower primary school teachers, they were appointed on the similar 1 or 2 years gap. They were appointed, my lord.
Very well. Yes.
On the same date they have appointed, my lord. Now, my lord,
Yes. Please.
my lord, with regard to the classification, Article 14, my lord, in my written notes, my lord, I have pointed out few points, my lord. The
Article 14 this has to be done. Article 14 is there, it has to be by a civil bench. Huh?
Violation.
Your writ petition is not
it's fine.
so you are challenging that in the DCLP school there cannot be two set of teachers.
Yes, my lord. Because my lord has to see why the Act of 1993 came into picture, my lord, by the legislature. Because prior to 1993, the primary schools were run and administered by the district councils, my lord. On the failure on the district council, state government stepped into the shoe and passed the enactment.
Yes.
Then, my lord, they used the term, an expression DCLP defined under Section 2E, my lord, and Section 2, my lord.
Yes.
Under Section 2, my lord, they have defined the categories of teachers, my lord, in Section 2E. One is, my lord, lower primary teachers, my lord. Another is, my lord, junior basic school teachers, my lord. These teachers and pre-primary. Pre-primary, they fail to include in the Parent Act. They are silent. But on the other hand, they are working in the same school, my lord. Same schools.
Working in the same school is not the test.
My lord.
In a same organization.
My lord, they are
suppose in a judiciary you have Munsef to the High Court judge.
Yes, my
but if you say it's a court of Meghalaya, So a Munse would say that I should get the salary of a High Court judge.
No.
Because no.
Cannot.
Why not? If we go by this is one genus. If it's one genus, so he will say that, well, Constitution permits me
Fine. Yes.
and I am there, so I am also deciding a matter, accepting that High Court may decide constitutional matters. Now here also, these senior teachers who are there, they are teaching some subjects which are not required to be taught by the lower primary section.
My lord, the
Same amount of segregation.
my lord, kindly, my lord, they are appointed by the same administrator. They are enjoying. I just received instruction from my colleague. They are enjoying the same pay scales, the pre-primary and the lower primary. In the same school, they are teaching in the same school, not in the different set of school, my lord. Which is why the intention of the legislature was to take over all the teachers, my lord. Not only one sect of teacher pick and choose from the primary section, my lord.
It depends upon the educational qualification.
My
The
lord.
education, your client's educational qualification and the educational qualification required for these posts are not the same.
My lord, in 90s, my lord. Now, if
Whatever maybe the 90s, forget about the 90s. They've brought about a change.
Well,
It's not to nullify. See, we are considering today whether this legislation is intended to nullify the judgment of Justice S.R. Sen,
yes, my lord.
affirmed by the division bench and
My-
went up to the Supreme Court.
My lord.
Correct?
My lord.
The state of law existing there and the state of law existing now has to be seen. They all proceed on the basis, if this amendment were there when this matter was decided,
Correct, my lord.
then the observations that made by this would have been different. Because because in that case there would have been
I
a
agree.
decision that, well, either they form the same class
Yes, my lord.
or they do not form the same class.
My lord, yes. I agree, my lord. To that, my lord. My lord.
Thank you.
I bow down to that, my lord.
Thank you.
Point,
We
my lord.
will consider your written notes of argument. Yes,
My
madam.
lord, now I'll just one small submission, my lord.
Yes.
Now, my lord, after passing the Amendment Act, my lord, in the year 2018, the similar set of teachers, my lord, the pre-primary, 186, they were approached before this honorable court, challenging the vires of the act, and we are hoping the matter would decide, my lord. But during the pendency of the matter, the state government
Has come with the amendment.
settlement, my lord. They release the same benefit at par with the lower primary, my lord. So now that amounts to,
See, that releasing the amount is nothing to do with the virus.
my lord,
That is a kind of estoppel, maybe.
my lord, yes, my lord.
Yes.
Now
This
we,
cannot be a ground for
after
filing.
that, my lord, we approached to the department. Department said that order that is the petitioners herein are not part of the writ proceeding, so deny it. That is a separate aspect. Now come to
Now
the, my
that
lord,
you file a read for a separate cause of action.
we cannot
If it
file
is
on that.
extended to one group,
We cannot
why
file
should not be
because
extended
because
to
of
the
Section 2 Amended Act, my lord. We are out. We are excluded, my lord. Now coming to the second point, my lord, Article 4, violation of Article 14, classification, my lord. My lord, that is the main argument.
other? Now it is your main argument.
my lord,
Yes.
that is the main. My case is on that, my lord. Classification.
But there is inadequate pleading in your writ petition. There's an inadequate pleading on this in the writ petition because your writ petition, excepting for one paragraph, all are nullifying the
yes,
scope
my
of
lord.
this.
My lord, I have pleaded, my lord. Though I have pleaded the
Only one paragraph that is completely unsubstantiated.
my lord. One paragraph, my lord, can be, my lord. Yes, my lord.
There's only one paragraph. You find the writ petition. No, writ petition.
Yes,
See,
my lord.
in the writ petition, there's only one paragraph. Paragraph 12, I believe. No, not paragraph 12. This paragraph is only one paragraph, I think. Paragraph 17 is the only paragraph.
Yes, my lord. I remember, my lord. Yes.
This distinction, the Supreme Court said it has to be clearly borne out from record and pleadings.
Yes, my lord.
The paragraph 12 is inadequate on that.
My lord,
You challenge that in a separate writ petition, we decide on this matter whether this violation or not.
my lord,
Second Amendment, according to respective of
if my lord can decide, my lord.
Yes. So we have heard you. We'll go through your judgments
My lord, yes, my lord.
and your written notes of
My lord,
arguments.
I deeply oblige, my lord, to that, my lord.
Anything else you want to argue?
My lord, only on classification and
This is the classification.
my lord, yes, I put forward my argument in my written notes, my lord. And the second is, my lord, then arbitrariness, how it arbitrary, my lord. I've relied on judgment.
That you have argued already.
Yes, my lord, my
And you
lord.
have already indicated the paragraphs, I believe.
Yes, my lord.
In this, you must have indicated the paragraph numbers.
Yes, my lord. In my
Yes. Well,
I've mentioned paragraph numbers. Yes,
have you given them the case laws?
well, I've given, my lord. I've given.
And you have gone through the written notes.
We received it just now outside the courtroom, my
Just
lord.
now?
Yes,
Yes,
my lord.
Because I finished, my lord, the evening, late evening, my lord, yesterday, my
So
lord.
when you on Article 14, they want to say there's a distinction. So when you will give your written notes,
Within 3 days, Lordship, by
3
Monday.
days.
Monday,
So
my
keep
lord.
it on Tuesday.
Lordship.
My lord. My lord.
We have heard the land counsel for the writ petitioner, the land counsel for the state has paid for time.
Item number 1.
Yes. Yes.
My lord, the respondent herein had filed a suit for a declaration of right title interest in respect of a portion of my property. But finally, the suit was decreed in his favor. Being aggrieved by that, I filed an appeal before the appellate court, along with an application for a condonation of delay. But while filing the application, inadvertently there was a typographical error, that is, instead of 104 days, it was typed 28 days. So we filed an application before the appellate court to allow us to amend the petition, which was finally allowed. Being aggrieved by that permission to correct the petition, my lord, the respondent filed a civil revision before this honorable court. And when this matter was reported to the appellate court stayed the proceeding of the case pending disposal of the matter in the High Court. But despite that, suddenly they started the proceeding without any notice to me and dismissed the appeal, my lord. So being aggrieved, I filed an application before the appellate court for restoration of the case, but that was not accepted. It was dismissed. And against that,
No, who is for the petitioner?
Yes, my lord.
Who is for the petitioner?
I am for the petition, my lord. Yeah.
No, you are challenging the order of
The
22nd
appellate,
November 2024.
yes, my lord.
Now, what has happened? What has happened?
Page 61, my lord. Is the
You filed a petition. You filed a petition, civil revision petition.
No.
They filed.
Before this honorable court, they filed.
Then what happened?
My lord, it happened like that. When the suit was decreed in favor of the respondent, being aggrieved by that, I filed an appeal before the appellate court, my lord, along with an application for condonation of delay. But in counting the delay by mistake, it was my
just a
lord.
minute. So they were the civil revisionist.
In the High Court, yes, my lord.
So that this case was dismissed.
No, my lord, when they filed a civil revision before this honorable court, the appellate court said that pending disposal of the revision, the proceeding will remain stayed before that.
So very well. So their civil revision got dismissed.
No, it was dismissed because first that they dismissed it. It was kept in abeyance, my lord. Without any notice, it was again reopened. And because of my absence, that appeal was dismissed. Then when this matter was present before this honorable court, the civil revision also is dismissed. Then again I went to the appellate court for restoration of my appeal.
No, your appeal, what was pending before the court? Your application was pending.
Yes, my lord.
Your application for?
For correction of the number of days for condonation of delay. That petition was pending. Hearing should have been there whether it should be condoned or not. But in the meantime, they came by civil revision that why I was allowed to amend the petition, my lord. You can come to page 47. That order is there, 6322. Page 47, my lord.
Mr. Philemon Nongbree.
Yes, my lord. They were
He
for
was the
the
advocate for the
civil revision in High Court.
opposite party.
Yes, here they are the. Yes, my lord.
Yes, counsel for the petitioner submits that this matter has since been rendered infructuous in much as the condonation application which has been allowed to be amended has been dismissed for default. So your application for condonation, that application was pending.
Yes, was pending.
That application was dismissed for default.
Yes, because without any notice, proceeding was started. Whereas as page 47,
No, their civil revision was
pending in the High Court, my lord.
No, their civil revision may have a bearing maybe on your application for condonation.
Yes, my lord.
So your condonation application, your application for condonation was
kept for
pending.
ABS pending
No, but why it was kept pending?
because the matter was pending in the High Court, my lord.
You filed a civil revision against which order?
No, condonation was not granted, my lord. Condonation was not granted. Only I was allowed to correct the days, number of days, which was wrongly typed, my lord. So that matter was pending.
No. You file a civil revision. Challenging which order? Challenging which order?
Ordinance 1760.
You have challenged the civil, you have filed a civil revision. Para 6. When the matter was initially upon the submission of petitioner to wait the outcome of the solution for hearing on the condemnation of the application. No. What is your application for revision? What was your revision application?
No, my lord, condonation was wrong. They wrongly made it.
No. What is the order which was, where is the civil, where is his application for, where is the application for civil revision?
My lord, please come to 65, page number 65, it is there.
Page 65.
Yes, my lord, that application. Page 60. It starts from page 61, my lord.
No, this is the impugned order here.
Yes. Against which now we have filed the revision.
What
is not
was
on
the,
record.
no, his revision application was against which order? $55.
65, Your Lordship. Page 65 of the impugned judgment. It's the impugned
65.
judgment itself. 65, Your Lordship.
Yes, page 65 is para 7.
The para 7, Your Lordship. Roman 7, Your Lordship.
Show cause was given respondent wherein they did not raise any specific objection as regards the proposed amendment. As regards the proposed amendment, the court is of the view that the proposed amendment is necessary for the purpose and the application for amendment is allowed. So application for amendment was allowed. You filed
Yes.
an
They filed
application
appeal.
for challenging that order.
Yes, ma'am. That is their case.
Yes.
You challenge the amendment order.
Yes.
Correct.
Yes.
Yes, Your Lordship. Yes, Your Lordship.
So what application was pending at that time? What was your application pending?
The same by which I was allowed to amend the petition, my lord.
So what was your application? What is which one dismissed? Where is that application? Where is that application which was ultimately dismissed?
It's not been annexed, Your Lordship.
That is the main thing. What is the application that was dismissed?
But before that, if your lordship can come to page 47, my lord, please come.
No. We want to see which application was dismissed.
Not here, my lord. If it could be, if could be taken, my lord, on Monday, I will bring that one. Otherwise, without that, I think it is not. by
No.
mistake.
Page 54 is possibly the application. Page 54 is not the application.
This is an application for restoration, my lord. The dismissed application.
No. What was the application pending before the trial court that was dismissed?
That was for correcting the petition, my lord.
Your amendment was allowed. So what correction?
No, amendment was allowed, my lord. No, amendment was allowed being aggrieved. They filed revision here. That's why it was allowed.
Exactly. Then
So then that petition was remained pending for hearing.
Why payment? That was allowed. The order says it is allowed.
Thereafter, question of condemnation was there, no, whether the condemnation should be allowed or not.
It already says the application, hence the application for amendment is allowed.
Yes.
So it may so happen that you did not carry out the amendment. That may be the position.
No, it was done. My lord, after
Unless you annex that, we don't know what is the application that was dismissed. This application, you filed an application, miss case number 2 of 23 for restoration of dismissed petition.
Yes.
So if it is already allowed, there is no dismissed petition. If your amendment is allowed, the question of dismissed petition doesn't arise.
My lord, amendment was allowed, then they filed a revision before this honorable court, my lord.
Correct.
Then the appellate court said, pending disposal of the revision petition, that matter will remain kept in abeyance, my lord.
Once the application is allowed, the question of keeping it abeyance doesn't arise. That is the finality of the proceeding, unless this is set aside by the High Court.
So that is the thing. It should not have been dismissed in that case.
No, why you file an application inviting trouble for yourself?
No, application I had to file for restoration because they dismissed my petition. But
your petition could not have been dismissed once it is allowed.
No, my lord, it was allowed. Then hearing should proceed for condonation of delay, my lord. Delay was not condoned.
For amendment, you don't require a application for condonation of delay. It says the court further observes, as regards the proposed amendment, the court is of the considered view that the proposed amendment is necessary, hence it is allowed. So your amendment, you asked for amendment, correct? Yes. That was allowed.
Yes, my lord.
So what was dismissed?
So that petition for condonation remains, my lord.
Which petition for condonation?
Your Lordship, what had happened in this matter is basically like after the amendment was allowed, after the CRP was filed, for 7 consecutive days, the petitioners were not represented, Your Lordship.
No, there was a delay of 104 days.
Yes, my lord.
In preferring the appeal.
Yes, my lord. So that matter was required to be heard, my lord.
Yes. Take down. Yes.
May I please your lordship?
Sorry?
May I please your lordship? I pray for some accommodation as a conducting
You're
counsel.
paying an accommodation? You are for the petitioner?
Petitioner, my lord.
What is this matter?
My lord, this is a revision against the order passed by the Judge District Council Court.
Regarding?
Your Honor, my lord, this petitioner herein has filed a suit and a missed case for deposit of rent.
You are not ready?
Your lordship, the conducting counsel, she has some personal difficulties, emergency difficulties.
November 2024 is the impugned judgment. Very well. And what is the order of this?
Against the order passed in.
Now, where is the order dated? 7 November 2023. 7 November 2023.
Page 64, Annexure 7, Your Lordship.
Page 64.
Page 64, Your Lordship.
Very well. Prayer for adjournment is made on behalf of